Okay, continuing chapter 15, the federal courts. I'm on page 466. Implementing court decisions. You remember we had an implementation section for bureaucracy, that when Congress makes laws, the difficulties of implementing congressional laws by bureaucratic agencies. Now we have implementing court decisions. The court makes a decision which can be, it's usually court decisions are called common law. I don't know if we call them common law from the Supreme Court, but we're implementing the court decision like law. The court conveys its decisions to the press and the public through formal announcements in open court. Media coverage of the court remains primitive, short, and shallow. Doris Graber reports that much reporting on the courts, even at the Supreme Court level, is imprecise and sometimes even wrong. More important to the legal community, the decisions are bound weekly and made available to every law library and lawyer in the U.S. I mentioned this in class, that the media and the way that the public hears court decisions are often exaggerated and inaccurate, and that's misunderstood. Whether or not it's ruled by a Supreme Court decision, is ruled by the Constitution, or is it by law, simple law? Is it a correction? Is it a big reach? Often it's not understood well. There is, of course, an air of finality to the public announcement of a decision. In fact, however, even Supreme Court decisions are not self-implementing. They are actually remands to lower courts, instructing them to act in accordance with the court's decision. Reacting bitterly to one of Chief Justice Marshall's decisions, President Andrew Jackson is said to have grumbled, "John Marshall has made his decision. Now let him enforce it." Said to have grumbled. We talk about it. We don't know if it's true. Court decisions carry legal, even moral authority, but courts must rely on other units of government to enforce their decisions. Judicial implementation refers to how and whether court decisions are translated into actual policy, thereby affecting the behavior of others. The Supreme Court works and has value because we believe in it. It's 9 judges. If we didn't hold them as valuable and their decisions as relevant and having meaning, we can just ignore it. Chief Justice Roberts is very aware of that. He's very aware of the air and the dignity of the Supreme Court and not overreaching, because if it got too, we don't have to, as a society, follow it. Nor does the president or Congress. We do because we believe in it. Judicial decision is the end of one process, the litigation process, and the beginning of another process, the process of judicial implementation. Sometimes delay and stalling follow even decisive court decisions. Despite a 1956 order from the U.S. Supreme Court to admit Virgil Hawkins to the University of Florida Law School, legal skirmishing continued and eventually produced a 1958 decision by a U.S. District Court in Florida ordering the admission of non-whites but upholding a denial of admissions to Hawkins. Thus, other courts and other institutions of government can be roadblocks in the way of judicial implementation. Charles Johnson and Bradley Cannon suggest that implementation of court decisions involves several elements. First, there is an interpreting population, heavily composed of lawyers and judges. They must correctly understand and reflect the intent of the original decision in their subsequent actions. Usually, lower court judges do follow the Supreme Court, but sometimes they circumvent higher court decisions to satisfy their own policy interests. So when the Supreme Court makes a decision, it becomes precedent and guidance for lower courts. But sometimes that can be an issue. Second, there is an the first one was interpreting population. Second, there is an implementing population. Suppose the court held, as it did, that prayers organized by school officials and the public are unconstitutional in public schools. The implementing population, school boards and school administrators whose schools are conducting prayers, must then actually abandon prayers. Police departments, hospitals, corporations, government agencies, all may be part of the implementing population. With so many implementers, many of whom may disagree with a decision, there is plenty of room for slippage between what the court decides and what actually occurs, as has been evident with school prayers. Then it can then another lawsuit can happen, or a threat of a lawsuit by a student or somebody else saying you're not following the law. Judicial decisions are more likely to be implemented smoothly if implementation is concentrated in the hands of a few highly visible officials, such as the president or state legislators. Even then, the court may face difficulties. Responding to the Brown decision ending legal segregation in the nation's public schools, the Board of Supervisors for Prince Edward County, abetted by changes in Virginia law, refused to give any funds for the county school board in 59. This action effectively closed all public schools in the county to avoid integrating them. The schools remained closed for 5 years until the legal process finally forced them to reopen. So they just shut down the schools. I assume, without looking it up, that many of them, the white students, ended up going to private schools. Third, every decision involves a consumer population. For example, the consumer population of an abortion decision is those people who may want to have an abortion and those who oppose them. The consumers of the Miranda decision on reading suspects their rights are criminal defendants and their attorneys. The consumer population must be aware of its newfound rights and stand up for them. And that gets back to the lawsuit. If you know that the violations of religion, the understanding of the Establishment Clause is happening in the school, you as a parent of a student sue. But that has, its own difficulties in your community as well. Implementers are more likely to comply with clearer court opinions. As a result, the court writes clearer opinions when it faces ideologically hostile and ideologically scattered lower federal courts. When it decides cases involving poorly performing federal agencies, when it decides cases involving states with less professionalized legislatures and governors, and when it rules against public opinion. Congress and presidents can also help or hinder judicial implementation. When the court, the year after its 54 decision in Brown v. Board, ordered public schools desegregated, quote, with all deliberate speed, President Eisenhower refused to state clearly that Americans should comply, which may have encouraged local school boards to resist the decision. Congress was not much help either. Only a decade later, in the wake of the civil rights movement, did it pass legislation denying federal aid to segregated schools. Different presidents have different commitments to a particular judicial policy. For example, the Obama administration decided not to defend the constitutionality of the 1996 Defense of Marriage Act. That gets back to the Solicitor General. So in 1996, Defense of Marriage Act was about states and same-sex marriage. Didn't have to recognize other states' same-sex marriage if you moved or traveled through. That was a 96 law, and then it was being challenged in the courts, and the Solicitor General said, as the lawyer of the U.S. government, we will not defend this law. Now, the ethics of that and the issue of that, when the president's Solicitor General will not defend a law, is a great discussion to have, because then it depends on who the president is on whether or not the law is defended in court. Doesn't mean that the law would lose. Doesn't mean the law would be struck down. Just because the Solicitor General doesn't defend it doesn't mean it's not still law. But, it does hinder it. Like all policymakers, the courts are choice makers. Ultimately, the choices they make affect us all. Confronted with controversial policies, they make controversial decisions that leave some people winners and others losers. The courts may have made policy about slavery and segregation, corporate power and capital punishment, and dozens of other controversial matters. Until the Civil War, the dominant questions before the court concerned slavery and the strength and legitimacy of the federal court. Remember back McCulloch, the bank question, and then Gibbons, the Commerce Clause question. You'll need to know those. Those are before the Civil War. These latter issues, legitimacy of the federal government, were resolved in favor of the supremacy of the federal court. From the Civil War until 1937, questions of the relationship between the federal government and the economy predominated. That would be the Progressive Era and Industrial Revolution. During this period, the court restricted the power of the federal government to regulate the economy. From 38 to the present, which would be the New Deal, Great Society, the expansion of presidential powers, etc. The paramount issue before the courts have concerned personal liberty and social and political equality. In this era, the court has enlarged the scope of personal freedom and civil rights and has removed many of the constitutional restraints on the regulation of the economy. Few justices played a more important role in making the court a significant national agenda setter than John Marshall, Chief Justice from 1801 to 1835. His successors have continued not only to respond to the political agenda, but also to shape discussion and debate about it. So you need to know John Marshall, Chief Justice who did Marbury v. Madison. You don't really need to know the details of the case, but you should read it, find it interesting. Read the case and then come down to here. Marshall devised a shrewd solution to the case of Marbury v. Madison. In February, so he's Chief Justice, he's going to write an opinion. In 1803, he delivered the unanimous opinion of the court. First, Marshall and his colleagues argued that Madison was wrong to withhold Marbury's commission. The court also found, however, that the Judiciary Act of 1789, under which Marbury had brought his lawsuit, contradicted the plain words of the Constitution about the court's original jurisdiction. Thus, Marshall dismissed Marbury's claim, saying that the court, according to the Constitution, had no power to require that the commission be delivered. So the argument is you're at the wrong court. Supreme Court does not have original jurisdiction pertaining to the Judiciary Act the Judiciary Act of 1789 violated the Constitution. That's judicial review. Judiciary Act of 1789 saying that Marbury had to go to the Supreme Court violated the Constitution because the Constitution does not say that the Supreme Court has original jurisdiction in a case like this. They have appellate. So they struck down the law, or that part of the law. Conceding a small battle over Marbury's commission, he did not get it. Marshall won a much larger war, asserting for the courts the power to determine what is and what is constitutional. As Marshall wrote, an act of the legislature repugnant to the Constitution is void. And it is emphatically the province and duty of the judicial department to say what the law is. The Chief Justice established the power of judicial review, the power of the courts to hold acts of Congress, and by implication, the executive, in violation of the Constitution. To note, although judicial review is not in the Constitution, and judicial review is normally Marbury v. Madison is referred to as the decision that created judicial review. There are writings from that time that it would be understood that the court probably would enact judicial review. They just didn't put the wording in the Constitution, though. So the Justice Marshall, by doing this, is the one, by doing it and no one stopping them, is making it their prerogative and their responsibility. Marbury v. Madison was part of a skirmish between the Federalists on the court and the Democratic-Republican-controlled Congress. Partly to rein in the Supreme Court, for example, Jeffersonian Congress in 1801 abolished the lower federal appeals court and made the Supreme Court judges return to the unpleasant task of riding the circuit. That's where you get circuit court. Think of circuit around a gym. You do a circuit. Serving as lower court judges around the country. This was an act of studied harassment of the court by its enemies. It's a good point to remember when people talk about how we treat the courts now and how politicized it is now. It was pretty bad throughout. There were times throughout the U.S. where Congress use the courts as a weapon against another party. After Marbury, angry members of Congress, together with other Jeffersonians, claimed that Marshall was a usurper of power, taking power that is not yours, setting himself above Congress and the president. This view, however, was unfair. Actually, people still think this issue. It's called the judicial supremacy, that why does the court get to be the decider? If Congress and president are two branches of government, why can one branch tell two branches they're wrong in the interpretation of the law and of the Constitution, more importantly of the Constitution, because they're co-equal branches. So I don't know about the unfair, given that this is still an argument that both liberals and conservatives make when they don't like court rulings. State courts before and after the Constitution had declared acts of their legislatures unconstitutional. In the Federalist Papers, Hamilton had expressly assumed the power of the federal courts to review legislation. So again, judicial review was assumed. And in fact, the federal courts had already used this power. Marbury was not even the first case to strike down an act of Congress, as a lower federal court had done so in 1792. And the Supreme Court itself had approved a law after constitutional review in 1796. Marshall was neither inventing nor imagining his right to review laws for their constitutionality. That part is true. As I had already said, it was already understood. The case illustrates that the courts must be politically astute in exercising their power over the other branches. By in effect reducing its own power, the authority to hear cases such as Marbury's under its original jurisdiction, the court was able to assert the right of judicial review in a fashion that the other branches could not easily rebuke. More than any other power of the courts, judicial review has embroiled the courts, in policy controversy. Before the Civil War, the Supreme Court, headed by Chief Justice Roger Taney, held the Missouri Compromise unconstitutional because it restricted slavery in the territories. The decision was one of many steps along the roads to the Civil War. This is a big one. That's the Dred Scott case. And it said that essentially black men could never be citizens. That was never the original intent of American citizenship. It's making slavery essentially arguably legal in all states and territories. It pretty much it didn't allow, there was no room now to compromise over slavery with the South. It is, though, the 14th Amendment that overrides the Dred Scott case. The decision was one of many steps along the road to the Civil War. After the Civil War, the court was again active, this time using judicial review to strike down dozens of state and federal laws, curbing the growing might of business corporations. So the courts were when the progressives come in during the Industrial Revolution, they're trying to curtail trusts, if you remember trust busting, and make laws about the economy and the industry. At first, the courts were not sympathetic to those laws. That has since changed. Okay, go ahead and read The Nine Old Men. I do not think I asked a question about it, but there's the court packing case. People still talk about, well, why not add judges if you think the court is skewed one way and you want it a different way? Go ahead. So that's under, read that. And then the Warren Court, I will read this one. You do need to know the Warren Court. It's a big deal for civil liberties. Few eras of the Supreme Court have been as active in shaping public policy as that of the Warren Court from 53 to 69. Presided over by Chief Justice Earl Warren, scarcely had President Eisenhower appointed Warren when the court faced the issue of school segregation. Actually, they had already heard the case. But then Warren replaced the former Supreme Court Chief Justice, and so they reheard it. In 54, it held that laws requiring segregation in the public schools were unconstitutional. This was a big deal, and we'll talk about it more later, because Chief Justice Earl Warren made sure that decision was unanimous, 9-0, so that it would be a strong message. Right now, a lot of our decisions, controversial decisions, might be 5-4 or even 6-3 now with a more conservative court, and that can hurt legitimacy. We can talk about that. Later, it expanded the rights of criminal defendants, extending the right to counsel, which is the Gideon case. When we watched the Gideon case, the presiding Chief Justice was Warren. And protections against unreasonable search and seizure and self-incrimination. that's pleading the fifth. It ordered states to reapportion both their legislatures and their congressional districts according to the principle one person, one vote. You got those cases already in the voting chapter. And it prohibited organized prayer in public schools. So active was the Warren Court that right-wing groups, fearing that it was remaking the country, posted billboards all over the U.S. urging Congress to impeach Earl Warren. So this Warren Court, and then consequently also the Roe v. Wade decision later, leads to organization and organizing by conservative, socially conservatives to change the court back. And they have been successful. Our court has been conservative for a while, and now it's 6-3. It's very conservative. And Chief Justice Roberts does know you could, if you go too far conservative, you could end up being like a Warren court where there's an active resistance and a backlash to the court. The court is, they're aware of that their decisions have an impact on people, as we already read, and therefore, people don't always agree or cooperate with the decisions. You need to read the Burger Court on your own. And then you need to read the Rehnquist and Roberts Court on your own as well. We are currently in the Roberts Court. Understanding the courts. Powerful courts are unusual. Few nations have them. The power of American judges raises questions about the compatibility of unelected courts with a democracy and about the appropriate role of the judiciary in policymaking. Announcing his retirement in 1981, Justice Potter Stewart made a few remarks to the handful of reporters present. Embedded in his brief statement was this observation, quote, "It seems to me that there's nothing more antithetical to the idea of what a good judge should be than to think it has something to do with representative democracy." He meant that judges should not be subject to the whims of popular majorities. In a nation that insists so strongly that it is democratic, where do the courts fit in? In some ways, the courts are not a very democratic institution. Federal judges are not elected and are almost impossible to remove. Indeed, their social backgrounds probably make the courts the most elite-dominated policymaking institution. If democracy requires that key policymakers always be elected or be continually responsible to those who are, then the courts diverge sharply from the requirements of democratic government. The Constitution's framers wanted it that way. Chief Justice Rehnquist, a judicial conservative, put the case as follows. Quote, "A mere change in public opinion since the adoption of the Constitution, unaccompanied by a constitutional amendment, should not change the meaning of the Constitution. A merely temporary majoritarian groundswell should not abrogate," look that word up, "some individual liberty protected by the Constitution." The courts are not entirely independent of popular preferences, however. Turn of the 20th century Chicago humorist Finley Peter Dunne had his Irish saloon keeper character, Mr. Dooley, quip that the Supreme Court, I'm not reading that the way it's written, the Supreme Court follows the, whatever that word is, returns. Okay. Can't help you on that one. Many years later, political scientists have found that the court usually reflects popular majorities. Even when the court seems out of step with other policymakers, it eventually swings around to join the policy consensus, as it did in the New Deal. A study of the period from 37 to 80 found that the court was clearly out of line with public opinion only on the issues of prayers in public schools. In addition, congressional court curbing proposals are typically driven by public discontent, and the court usually responds to such proposals by engaging in self-restraint and moderating its decisions. They are aware there are only 9 judges. If they make too many decisions and the majority is against it, that can cause destabilization of their authority. Similarly, the court often moves towards the position articulated on behalf of the White House by the Solicitor General. I don't know how true that, historically that's true, but with the whiplash going on between different views on court cases, when new presidents come in, I don't know if they can use the Solicitor General as guidance. Finally, there is reason to believe that the court restrains itself when it's concerned with difficulties in implementing its decisions because of broad opposition. So again, It's a be careful what you ask for. Many people might say, I want the court to make this decision. It's the right thing to do. I don't care what the outcome is. It can be destabilizing. Despite the fact, and it's called judicial supremacy, as I said before already, books are written about this. Despite the fact that the Supreme Court sits in a marble palace, it is not insulated from the normal forms of politics, as one might think. For example, when the court took up Webster v. Reproductive Health Services, 1989, the two sides in the abortion debate flooded the court with mail, targeted it with advertisements and protests, and bombarded it with 78 amicus briefs. Members of the Supreme Court are unlikely to cave into interest group pressures. They don't answer to them, but they are aware of the public's concerns about issues, and this awareness becomes part of their consciousness as they decide cases. Political scientists have found that the court is more likely to hear cases for which interest groups have filed amicus briefs, and that such briefs may make a difference in the court's decisions. We don't know. Courts can also promote pluralism. When groups go to court, they use litigation to achieve their policy objectives. Both civil rights groups and environmentalists, for example, have blazed a path to show how interest groups can effectively use the courts to achieve their policy goals. It's becoming more and more of the case. Thurgood Marshall, the legal wizard of the NAACP's litigation strategy, not only won most of his cases, but also won for himself, or I would say earned for himself, a seat on the Supreme Court. Almost every major policy decision these days ends up in court. Chances are good that some judge can be found who will rule in an interest group's favor. On the other hand, agencies and businesses commonly find themselves ordered by different courts to do opposite things. The habit is always turning to the courts as a last resort can add to policy delay, deadlock, and inconsistency. And again, I would also say that unfair to the court, when many of their rulings, there was one that they were mad about Barrett making before she became Supreme Court Justice, are rulings based on the law. If you don't like the law, change the law. And sometimes that gets caught up in people expecting the courts to side with them. Because just like Congress can make laws to change, often change judicial decisions, or can make a law instead of relying on the Constitution. So as remember, we look to the president when Congress could actually make laws and override vetoes. The whole thing is supposed to be checks and balances, but that gets difficult. Okay, I'm going right to the end. Scope of judicial power. The courts, Alexander Hamilton wrote in Federalist Papers, will be least in capacity to annoy or injure the people and their liberties. Okay. Throughout American history, the critics of judicial power have disagreed. They see the courts as too powerful for their own or the nation's good. Yesterday's critics focused on John Marshall's usurpations of power, or on the pro-slavery decision of Dred Scott, or on the efforts of the 9 old men to kill off FDR's New Deal legislation. Today's critics are never short of arguments to show that courts go too far in making policy when they don't like the policy, I should say. Courts make policy on both large and small issues. In the past few decades, courts have made policies on major issues involving school busing, abortion, affirmative action, nuclear power, legislative redistricting, bilingual education, prison conditions, counting votes in the 2000 presidential election, healthcare reform, and many others. There are strong disagreements about the appropriateness of the courts playing a prominent policy-making role. Many scholars and judges favor a policy of judicial restraint, in which judges adhere closely to precedent and play minimal policy-making roles, deferring to legislatures by upholding laws whenever possible. These observers stress that the federal courts, composed of unelected judges, are the least democratic branch of government, and question the qualification of judges for making policy decisions and policy interests. Advocates of judicial restraint believe these decisions, such as those on abortion and prayer in public schools, go well beyond the referee role they say is appropriate for policy in a democracy. If you are a scholar, if you write books, if you're a historian, if you're a legal expert, I respect the argument of judicial restraint. But if you hear a politician say they believe in judicial restraint, question that. Just like I'll question any average person who says, I believe in judicial restraint. Because really, if you look at what they say, for example, people who believe in judicial restraint are angry about Roe v. Wade, and they should be. They disagree with a lot of those decisions. But they're also the same people who wanted Obamacare or the Affordable Care Act, which is a law made by Congress, signed by the president, overturned by the Supreme Court. And that's not judicial restraint. That's judicial activism. At least I would argue. So be careful in believing judicial restraint when it comes out of politicians' mouths. It usually means judicial restraint and judicial activism out of politicians' mouths mean the court needs to decide the way I want them to decide. So they throw this word judicial activism to really mean the court's making decisions I don't like. And again, I'm not saying judicial restraint, judicial activism aren't legit arguments. It's just careful who's giving the argument. Read people who don't have a political agenda. Read their opinions, not those who have political agendas and saying, complaining. On the other side are proponents of judicial activism, which judges are less deferential to elected officials and sometimes make bold policy decisions, even charting new constitutional ground. Advocates of judicial activism emphasize that the courts may alleviate pressing needs, especially needs of those who are politically or economically weak, left unmet by the majoritarian political process. They would argue this, that if you have a majority rule and everyone votes, people vote to take other people's rights away. And majority can't vote to take other people's rights away. If it's a right, it's a right. And it's the court that is the one blocking that. Of course, that again, when this word is used politically, judicial activism, judicial restraint, be hesitant on that, on the strength of those arguments. Americans have never resolved the issue of judicial restraint versus judicial activism. Republicans, spurred by their opposition of the court's liberal decisions on issues such as school prayer, defendants' rights, flag burning, and abortion, usually call for justices to exercise judicial restraint. However, the justices they nominate are often not deferential to Congress and vote to strike down acts of Congress, furthering conservative goals in the process, but undermining judicial restraint. Democrats often favor judicial activism, but are highly critical of conservative courts undermining liberal policies, whether in the early years of the New Deal or in the past 3 decades. It is important not to confuse judicial activism or restraint with liberalism or conservatism. In the chart, you can see the varying levels of the court's use of judicial review to void laws passed by Congress in different eras. In the early years of the New Deal, judicial activists were conservatives. During the tenure of Earl Warren, activists made liberal decisions. The court under Burger Rehnquist and Roberts, composed of mostly conservative nominees by Republican presidents, marked the most active use in the nation's history of judicial review to avoid congressional legislation. So again, it's not, you will hear activism and restraint politically, but they're not using it right. They have an agenda. It has a different meaning. The problem remains of reconciling the American democratic heritage with an active policymaking role for the judiciary. The federal courts have developed a doctrine of political questions as a means to avoid deciding some cases, principally those that involve conflicts between the president and Congress. The courts have shown no willingness, for example, to just settle disputes regarding the constitutionality of the War Powers Resolution, which Congress designed to constrain the president's use of force. Remember the War Powers Act and the argument that it's probably unconstitutional. Well, the courts haven't ruled. They don't want to weigh in on that if they don't have to. Similarly, judges typically attempt whenever possible to avoid deciding a case on the basis of the Constitution, preferring less contentious technical grounds. They also employ issues of jurisdiction, mootness, whether a case presents a real controversy in which a judicial decision can have a practical effect, standing to sue, ripeness, whether the issue of the case are clear enough and involve enough to serve as the basis of a decision, and other conditions to avoid adjudication of some politically charged cases. I talked about this in class. They want to avoid them. They know that there's consequences in taking on these decisions for society. The Supreme Court refused to decide, for example, whether it was legal to carry out the war in Vietnam without an explicit declaration of war from Congress. I would argue there was a declaration of war, it just wasn't explicit. And they want to avoid that. They're not going there. Another one they try to avoid is dealing with foreign policy. The Supreme Court the courts prefer to stay out of foreign policy issues. For example, Guantanamo Bay, where we have people sitting, detainees, who have never had a day in court. They did deal with that issue. There was controversy on that. And there's way more to it than I'm going to here. You'll have to pick up the book. As you saw in when I say the book, a book written about it, as you saw in the discussion of Marbury v. Madison, from the earliest days of the Republic, federal judges have been politically astute in their efforts to maintain the legitimacy and of the judiciary and to conserve their resources, which is to be expected since judges are typically recruited from political backgrounds. They have tried not to take on too many politically controversial issues at one time. They have also been much more likely to find state and local laws unconstitutional than federal laws. Another factor that increases the acceptability of, I find that interesting, they find more state and local laws unconstitutional than federal. I'm not sure how that works and what the timing is on that. Anyway, I'm going to move on. Another factor that increases the acceptability of activist courts is the ability to overturn their decisions. First, the president and the Senate determine who sits on the federal bench. The second, of course, then they stay there for life. Second, Congress, with or without the president's urging, can begin the process of amending the Constitution to overcome a constitutional decision of the Supreme Court. Although this process does not occur rapidly, it is a safety valve. The 11th Amendment in 1795 reversed the decision of Chisholm, v. Georgia, which permitted an individual to sue a state in federal court. The 14th Amendment, 1868, reversed the decision in Dred Scott v. Sanford, which held African Americans not to be citizens of the U.S. The 16th Amendment in 1913 reversed the decision in Pollock v. Farmers Loan, which prohibited a federal income tax. And the 26th Amendment in 71 reversed part of Oregon v. Mitchell, which voided a congressional act according 18 to 20-year-olds the right to vote in state elections. There was a congressional act for 18 to 20-year-olds. Oregon v. Mitchell said that was unconstitutional, so they made the amendment. Another amendment. Now, they made a court decision they made a constitutional amendment that all Black men cannot be denied the right to vote based on race. That is the 15th Amendment, but it was never really enforced until the Voting Rights Act of 65, which gets into issues of implementation yet again. Just a side note. Even more drastic options are available as well. Just before leaving office in 1801, the Federalists created a tier of circuit courts and populated them with Federalist judges. The Jeffersonian Democrats took over the reins of power and promptly abolished the entire level of courts. In 1869, the Radical Republicans in Congress altered the appellate jurisdiction of the Supreme Court to prevent it from hearing a case that concerned the Reconstruction Acts. So when you hear about wanting to change the courts, it does happen. The kind of alteration is rare, but it occurred recently. The George W. Bush administration selected the naval base at Guantanamo as the site for a detention camp for terrorism suspects in the expectation that its actions would not be subject to review by federal courts. In June 2004, however, the court ruled that the naval base fell within the jurisdiction of U.S. law and that the habeas corpus statute that allows prisoners to challenge their detentions was applicable. That's the case in 2005 and again in 2006, Congress stripped federal courts from hearing habeas corpus petitions from the detainees in an attempt to thwart prisoners from seeking judicial relief. In the end, however, the Supreme Court held Congress's actions to be unconstitutional. This was a big deal because it's foreign policy. or arguably foreign policy. Usually they don't like to touch that, but they did on this particular situation. Finally, if the issue is one of statutory construction in which a court interprets an act of Congress, then the legislature routinely passes legislation that clarifies existing law and, in effect, overturns the courts. In 84, for example, the court ruled in Grove City College v. Bell that Congress had intended that when an institution receives federal aid, only the program or activity that actually gets the aid, not the entire institution, is covered by 4 federal civil rights laws. In 88, Congress passed a law specifying that the entire institution is affected. Congress may also pass laws with detailed language to constrain judicial decision-making. Description of the judiciary as the, quote, ultimate arbiter of the Constitution is hyperbolic. It's a hard all the branches of government help define and shape the Constitution. Again, I don't know. That's opinion. There are people who argue both on the left and the right that the Supreme Court is the ultimate arbiter of the Constitution because it's hard to pass, if not impossible to pass an amendment. It's now very difficult, at times impossible, to change a law. But then again, I guess you could argue back then that's Congress and president's fault that the court is being the ultimate decider. Congress and president could pick it up. Okay, that ends this chapter.